So we have our resource person, Dr. S. Balakrishnan, Professor and Head, Department of Computer Science and Business System at Sri Krishna College of Engineering and Technology, Coimbatore. So he has 18 years of experience in teaching, research and administration. He has published over 15 books, 6 book chapters, 23 technical articles in CSI Communication magazines, 24 technical blogs, 1 article in Electronics for You magazine, 5 articles in Open Source for You magazine, and over 100 plus publications in highly cited journals and conferences. Some of his professional awards include Faculty with Maximum Publishing in CSI Communications 2017 to 19, International Data Science Writer of the Year 2019, MTC Global Outstanding Researcher Award, Contributors Competition winner July 2019 to December 2019 by Data Science Foundation with a cash prize of 100 euros. 100 Inspiring Authors of India, Deloitte Innovation Award cash prize rupees 10,000 from Deloitte for Smart India Hackathon 2018. Patent Published Award, Impactful Author of the Year 1718. So his research interests are artificial intelligence, cloud computing and IoT. He has delivered several guest lectures, seminars and chaired a session for various conferences. He is serving as a reviewer and editorial board member of many reputed journals and acted as session chair and technical program committee member of national conferences and international conferences at Vietnam, China, America and Bangkok. He has published more than 21 patents on IoT applications and 1 granted copyright. So we have such a resource person, eminent research person with us. So over to you, sir.
Good evening to everyone. Thank you so much for Manoj. Manoj, please mute us. Make it up.
Yes, sir.
Yeah, thank you so much for nice introduction. It gives me a great pleasure for me to extend my wishes to all the participants. So the today topic, so as per the IIC, that Institutions Innovation Council direction, today's topic is inter-college webinar on intellectual property rights. So the 21st century was termed as a century of knowledge. However, merely having the knowledge is not enough. The production of that knowledge and conversion of that knowledge into the profit are important for the survival of any high-tech business and economy. So the intellectual property rights law and the food and drug laws provide the pharmaceutical and the biotechnology industry with this unparalleled production. So these laws, these IPR laws provide exclusivity, patent term restoration, patent extension under the various conditions unmatched by any other industry. So the today's topic is that IPR, intellectual property right. So as per the So what is intellectual property? That is IP. IP rights or intellectual property rights or like any other property rights, they allow the creators or owners of patent, trademark or copyright works to benefit from their own work or investment in a creation. Can you hear me? Is it okay, Manoj?
We can hear you, sir. Yes, sir, we can hear you, sir.
Yeah. So the IP is a property which cannot be touched or seen and is a product of a person's intelligence, hard work and some skills, some technical skills. So like real property, the IP, the intellectual property can be bought or it can be sold or it can be licensed or it can be exchanged or it can be given away. So the owners can prevent unauthorized use and can take the legal action in case someone else uses it without their permission. So that is the word intellect refers to creations of mind. So the IP means the property so which is created with intellect, such as inventions of something, some new inventions, books, paintings, songs, symbols, names, images or designs used in the business, etc. Some legal rights conferred on that such property are called as the intellectual property right. So that IP, that intellectual property, is a type of intangible property, and it includes the inventions, some sort of literary work, and some artistic work, or some symbols, or some names, or painting, etc. So the IPR are the protection granted to the creators of the intellectual property by the government. And another important thing, the IPR are the territorial in nature. For the production of IP in any country, the one has to seek the production separately under the relevant laws. So these are the special mechanisms in place in various territories for providing the protection to different types of IPR. So this is the introduction about the IPR. So the IPR, we mean that is a think, learn, brain, and creativity and idea, and from the different mind like that. So what are the different types of IPR? So the IPR may be in terms of some 8 to 9 types. We'll start with the copyright, trademark, geographical indication, design. Another important thing, patent, trade secret, semiconductor IC layout, design, plan, variety. So these are some of the IPR. So apart from here, the patent is nothing but here for every individual improved mechanism. So the technology oriented thing. So that under the patent, the design is nothing but for the outer shape and some sort of configuration under the design. Trademark is nothing but is a brand name or logo for the goods denoted by the art. That is a registered one. So that is a trademark. Trade secret is nothing but it's a client list or some formula of a product like that. And copyright is nothing but music, some artistic work, and like that. It's denoted as a copyright. So in the upcoming slide, we will see what is copyright, trademark, design, what are the different patterns, how to file, publish the patents, and trade secret, what is the plan variety, and what is the semiconductor IC layout design. So the upcoming session, upcoming slides, we will see one by one. So what are the benefits of IP registration? So what are the advantages or what are the benefits whenever we go for the intellectual property registration? The first important benefit is, we may say, is the economic benefit. The economic benefits in the sense, whenever IP rights enable the creators to protect and monetize their creations, so the third party cannot use this such a creation without authorization from the creator. So the owner is a sole responsibility for that. So without owner or without the creator of the particular patent or particular IP, the particular person cannot use that thing. So we may get economical benefit in terms of that. Second important benefit is the benefits consumers and the society. So it provides a consumer with innovation, innovative products and services. The third important thing is we are encouraging innovation. So the benefits of IP registration, indirectly we are, that's a very important, indirectly we are focusing about the innovation. So all the way we are encouraging the new things. So the innovation, it promotes the innovation and increases the funding for the research and development. So all the funded agencies, they are encourages the person, or they are encourages the innovators or creators in terms of that IP registration like that. Fourth important benefit is the establishes the ownership. So who is holding or who is having the idea, or who is the creator of that idea. So he is a better person. He is holding such a licensing thing. So that establishes the ownership. That is the fourth important benefit. The fifth important benefit is the legal benefit. So all the way any if suppose we go for getting if you registered IP, then automatically the legal benefits will be legal issues will be avoided. So that is a very important benefit, legal benefit. So these are the benefits of IP registration. So the benefits of IP registration: first one is economic benefit, second one is the benefits consumer and society, third one is it establishes the ownership, fourth important thing is the innovation, and fifth one is the legal benefit. So these are the benefits of IP registration. IP may be any registration, either copyright, patent, trademark, design, or trade secret, anything. So these are the benefits. Next important, effects of non-registration or grant. So what are the effects? So the first effect, It is difficult to obtain the relief in the case of the infringement. So non-registered IPs have weak evidential value or like that. So second thing, only remedies under the civil law can be availed. So the owners cannot obtain the remedies under the criminal law. So that is the effect of the non-registration. So the third one is the who can obtain the production. So who are all or who can obtain the production. So any person or any owner, who is a creator, so the person who is a creator of an original and creative or some innovative work, having the principal place of business in India, or if he does not carry out the business in India, has a place of the service in India, can obtain such a production. So these are the the owner or creator of the particular idea. So he can obtain the production. So next, how are IPRs are registered or granted in India? So all the applications of IPR need to be filed at the appropriate IPR office in the prescribed format. We will see what are the different formats are there, what are the different IPR offices are there in India. So next, the application is examined as per the status, and the IPR is granted or registered or refused. So these are the different way. These are the different important things. And also indirectly we are getting so many benefits for the IP registration, and who are all the obtaining the protection with the help of that IP. And next, how we are IP registered or granted in India. So that is a thing. So the first important thing, first IP, intellectual property is copyright. Actually, the copyright is an exclusive legal right granted to creators on expression of an idea. So the copyright owner has the rights to reproduce or translate or adopt or perform or distribute and publicly display the work, etc. So as the author of the work, the copyright, it may be any work, any literary work, or any art-oriented work. So any music or anything. So these are the things. These are under the category of copyright. Even suppose if you what so the registration is not mandatory, since the copyright comes into existence as soon as the intellectual work is created. So as the author of the work, you alone have the right to do any of the following or do any of the things. So the first thing, to produce a work in a material form, any work, so say we made a book work like that, any manual, lab manual or any sort of work. So that work may be considered for the copyright. So to produce a work in the material form. Next, to publish the work. Suppose if you finish your PhD and your thesis work, the thesis work may be considered for the copyright because this is under the literary work. So you may go for copyright. So that is to publish the work, to perform the work in public. So any work, any artistic work or any literary work in the public, that also applicable for the copyright. Next, to produce or reproduce or publish any translation of the work. So suppose you are translating English to Tamil. So that type of thing. So that is you are the owner or you are the creator of such a translation or translator. In that case, you may go for the copyright. You may go for registering the copyright. And another very important thing, to make any film, cinematograph, film, or any audio work or anything that recording in respect of the work, so that is applicable for the copyright. And to make any adoption of the work or any due in the relation to the translation or any adaptation of the work, that is also another important thing. However, having a copyright registration is a strong proof of your ownership. Make your copyright work with the copyright symbol, that is a C, that with the round, that is a symbol, is that is called as a copyright symbol. So your name of your year of creation, like that. So we will see in the upcoming slide how we are making it, what is the difference between copyright and what is the difference between C and R, like that. So once you registered copyright, you make it C, like that. We will see. So next, what are the works covered under the copyright? So the first, these are the six categories of work. First work is the literary work. That is a literary work. It may be a book, or it may be a newspaper article, or it may be some technical blogs, or it may be any novel, or any poem, or any lab manual, or any inspection manual, any type of any sort of speech, any computer software, that is a computer program. So these work under the category of literary work. So literary work including software, that is that type of that kind of work belongs to the category of copyright. Second important thing is a dramatic work, that is artistic work. So as per the artistic work, any drawing or painting, logo, map, chart, photograph, or any work, any sort of architecture. So that architecture belongs to your own what uh, own work. In that case, you may go for copyright like that. So that belongs to the category of artistic. The third important category is a dramatic, that is any screenplay or any drama, any such kind of activity that thing is belongs to the copyright category under the dramatic category. The fourth important category is a musical, any musical note or any musical that particular uh, what recordings, sounds, particular sound belongs to the musical category, that copyright under the copyright, and sound recording. So some sort of sound that belongs to that copyright, and cinematograph films, visual recording which includes sound with audio, audio with video. So that type of thing belongs to the copyright. So basically, the copyright having these six under this six category. It may be literary, it may be a dramatic, it may be a sound recording, it may be artistic, or it may be a musical one, or it may be a cinematograph films. So as per actually, as we are the technical person, as we are the technical person, we actually our work may be protected under the literary work. So in the name of that copyright. So copyright in the name of that literary work like that. So that is a important thing under the copyright. So works covered under the copyright. So that is a thing. So literary work, any kind of literary, any kind of art, any technical blog or any technical articles or anything, that literary work, that lifetime of that work is 60 years from the date of the author. So that is a 60 years until that lifetime of the author, and until the 60 years from the date of the author. So that is a thing. The next anonymous or pseudo-anonymous works is 60 years from the works was first published. Then works of any public undertaking or government related work, that is 60 years from the work was first published. And work of the international organization, that is 60 years from work was first published. The sound recording is also the validity of that such a copyright is 60 years. And cinematograph film is also what that lifetime or duration of the particular copyright is 60 years, which the film was published. That is these are the duration, or these are the lifetime of the particular copyright. So next important thing, second important IP, that is intellectual property. First one is the copyright. Second intellectual property is a trademark. So all the way we know about what is the trademark. So all the way we are using so many designs or so many letters or so many signs like that. So all belongs to the category of trademark. So trademark is nothing but it's any name, any name or any word or any sound, any numeral, any colors or any symbol or a drawing or combination of all these things. So that is this is a capable. This combination of these are capable of distinguishing some goods or services of one product from another product shall be capable of that constituting a trademark. So Coca-Cola. So whenever you see the color with that brand that text, that is that name of the Coca-Cola, easily we can identify the thing. So this belongs to this category. So this is one important trademark. And PMW, that logo of PMW with that name, that word PMW. So that name, that itself is a one trademark. So such as whenever go for this such a trademark, the trademark including any personal name also, the personal name, letters or anything. So just like that, the TVS. So whenever we see the name, the TVS is the name of the person, but it's under the trademark category. So like that. So the trademark should not be identical or it's similar. So whenever go for that thing, whenever suppose any person are buying the any item or any product or anything, it would be confused. So for avoiding such a thing, we are making a trademark. So the following things can be registered as a trademark. So that is a letter, numeral, drawing, symbol, or any two-dimensional images, or any three-dimensional images also make it as a trademark. So in a single brand or logo, the trademark can let you know the many things about a company's reputation or some company product and some company services like that. So example, so many examples are there. For a logo, so logo, the example Google logo on the slide. So whenever we are seeing about the Google, easily we can identify that the logo itself, we can identify it belongs to that the trademark of the Google like that. So whenever we will see the Pepsi or Coca-Cola bottle packaging, so the packaging itself easily we can identify this belongs to this trademark like that. So even for the Vodafone, so Vodafone having some earlier days the Vodafone mobile phone services. So in that Vodafone we are having the service mark. One service mark is there. So these are some of the trademarks. Apart from that, some non-traditional trademark is also there. So the non-traditional trademark is nothing but for even we may say the sound or some sort of smell, color or color combination or shape can be that also we can take it under the trademark category. So these are suppose for example you see the Coca-Cola. Here the Coca-Cola bottle shape. So the bottle shape is the one trademark. And another thing we are seeing that what Rolls Royce, the car is there. So the car that Rolls Royce car here one shape is there. So that shape is without seeing that Rolls Royce the shape it's identifying that shape itself easily we can identify this car belongs to the Rolls Royce like that. So these are the important trademark. So the trademark is a symbol of origin and a source of a mark, and it bears a stamp of quality. So that is also very important thing. So the trademark owner should always want to protect mark from the unfair usage and also from the fraud and data that deceit. So that's why the trademark is registered for 10 years and it can be successfully that renewed. So that is a validity of the trademark is once registered only for 10 years only. Then after that, whenever we want after the 10 years, we may go for the renewing the things. So that is a important thing. So that is a trademark. So that is the second trademark, that is the second IP. Second intellectual property is nothing but the trademark. So what are the essentials of trademark? So what are the essentials of trademark? So we may say, can the trademark be entirely descriptive? So yes, we may say yes, the trademark can be entirely descriptive one. Here the advisable, whenever go for the essential of the trademark, the trademark, what are the notations or what are the rules to be followed while filing the trademark? First thing is the trademark. The trademark should be unique. That is the example, Doordarshan. So it's a unique name. So that is a name itself. With the help of that name, we can say that Doordarshan is a unique name like that. So next, it should be distinctive. So it should be a distinctive like the example BIM and bell. So the bell is we know the bell is nothing but heavy electrical. So with the help of whenever we see the name BHEL, we can identify this belongs to this trademark or this industry like that. So it should be a distinctive one. And another third important thing whenever go for making or whenever go for putting the trademark, that trademark should be it's a non-dictionary word or it's an invented word like that. So that is a thing. So another important thing, the particular when I go for the design-oriented trademark, it should be the custom design. And another fifth advisable, fifth one is the fifth important thing is it may be any devices or any symbols like that. So that devices or symbols should be made in India like that. So that is a very important thing. So whenever go for the trademark, whenever go for the trademark, which is it's easy to speak as well as this spelling. So that we have to easily spell out. So that is a very important thing. And another important thing, when I go for that such a type of trademark name, it should be appealing and it's easy to remember or recollecting the thing. And the third important thing, it should be invented or coined word or it's a unique monogram or logo or some geometrical device like that. So what are the things are we don't use words or don't use a thing when I go for the trademark means first thing we cannot use the adjective. Example efficient or like that. So that adjective word cannot be used in the trademark. Second important thing is the name of the person or places. So name of the person or places Rahul Kumar or like that it cannot be used. So that is a wrong way of representing a wrong way of filing or registering it, any trademark. The third important thing is obscenity. So that is also not important thing, not a valid one. So the fourth one is it may be as a religious. We cannot denote like a religious word or any constitutional word like that. And even for the common shapes, that also we cannot mention it. That is the thing. So the whenever go for that avoiding, whenever go for making, whenever go for registering such a trademark, these are the important things we have to consider. So the left side part is a do and right side part is a don't. So we are so just keep in your mind. So these are the important points. Based on that, we may go for filing or we may go for registering such a trademark. So that is a trademark. So how to indicate your trademarks? So we are having TM and R. So the TM in the sense whenever the trademark, whenever we are registering for any new item or new things. So suppose if you go for registered, so after registering such a thing, it make it after filing or after registering thing, just it make it as a thing. Once you got the registration, once you registered, once after approval, after getting the approval, you make it as a R. So the left side is the trademark application, the TM. So TM is nothing but trademark application has been filed. So whenever go for filing, so filing or the registration is under process, that is the TM. After the registration, once the registration is over, so once the verification is over, then we are supposed to get that what the trademark should be registered form. That is called as a R. So there is a difference between TM and R. TM is a under process for the registration. R is nothing but is a registered one. So that is a in between TM and R. So that is a once you recognize a registered trademark by the symbol or the circle with the R means that is a trademark name or the graphical image is a registered one like that. So that is a thing. So next, here some of the actually activity. Here, can you find some of the famous trademark in that table? Can you find some of the famous trademark? Yeah, so many trademarks are there. Pepsi is a one trademark. That link is another trademark. Then Amul, Cadbury, Tata, Dettol. Next. Bata, Horlicks, Lux. So these are some of the famous trademarks. So they actually whenever seeing the trademark name itself, we can easily identify this belongs to this category. So Amul belongs to that food oriented thing. Pepsi belongs to food oriented thing. Like that. So easily we can identify. Easily we can Bata belongs to what category like that. So that is some of the famous trademarks. Already they got the trademark. They got the trademark, also the registered trademark. These are some of the registered trademark. So next, very important. As we are the technical person, so our next very important thing is the patent. So the patent is an exclusive right granted, which provides the exclude of all other that all others and prevent them from making or using offering or for sale or selling or importing your inventions like that. So the invention is nothing but in simple terms we may refer it's a new product or new process which is a technical advancement over the existing knowledge or has economic significance of or significance or both the things. So the invention, whenever go for the new invention, whenever the importing that invention, that invention can be a patentable. So the invention is nothing but it may be a new product or new process. That product or process may be a technical advancement over the existing knowledge or some sort of economic significance or both the things. So for an invention, any invention to be patentable, it must be a new. That is, it is not something already existing in the current knowledge anywhere in the world. That is, it's not in the public domain in any form before filing of the patent application. So that is, it must be new means it should be that it should have the novelty. That is a novelty. That is the first part. Whenever the particular information or particular technical thing should be in the form of should not be disclosed. So it is not in the public domain in any form. So that is a novelty. So first point is a novelty. So novel idea, novel things can be patented. Second important thing is it must be known or obvious to any person who is skilled in the relevant field of technology. We may say that is a standard is a person reasonably skilled in such a field of study and not a layman. So that is we may say some inventive steps, some sort of inventive steps. That is a second important thing. So new inventions. New inventions can be a patented. Third important thing, some sort of industrial use. It must be capable of industrial application. So capable of being applied to the practical utilities and not just the pure theory. So any industrial use instead of the theoretical things, it should be in the form of some practical, or it should be useful in the industrial use. So that type of application can be patented. So the patent is valid for 20 years, starting from the date of filing of the patent application, and this term cannot be extended. But nowadays, actually, still some hearing is going on for extending this patent, the validity of the patent. So some court cases is going on for extending that 20 years into some other years. So the patent validity is only 20 years after filing, starting from the filing of the patent. So that is an important thing. So whenever go for the patent, some automobile company use the technology to build a new sectors in the car market. So that type of idea can be patented. So the patent is valid within the territory of the country. So the patent may be varied from the country to country. So we'll see it. So that is an important thing. So what are non-patentable inventions? So non-patentable invention. So some few examples of non-patentable inventions are. So as per the section 3 and 4 of the Patent Act, so the Patent Act, we have the Patent Act section 3 and 4, it deals with the non-patentable inventions. So some of the non-patentable inventions are there. Suppose first one, a method of treatment of humans and animals. So that if any treatment, any sort of treatment for the human or animal, that cannot be patented. The second thing, the invention that causes serious prejudice to the human or animal or plant life or any health issue or to the environment, that type of thing cannot be patented. Computer programs or algorithms, that also cannot be patented. Computer programs and algorithms may be go for the copyright, but it cannot be patented. So the mere discovery of a new form of known substance, so that is also not non-patented. Next, the mixing of some aggregation of some property, something cannot, some chemical oriented thing, or some method of playing game, so that cannot be patented. The presentation of the abstract idea, so that definitely that cannot be patented. Inventions containing the traditional knowledge, so suppose that also not patentable. Traditional knowledge means suppose we are using the turmeric. So from the turmeric we are using some sort of medicine or like that. That is also not applicable for the patent or like that. The presentation of the abstract ideas, inventions contrary to the natural laws, mathematical or business method, a method of the agriculture, invention which fall under the Atomic Energy Act. So these are the things. These are the inventions cannot be patentable. So that is a very important thing. So as per the patent section 3 and 4, these concepts or these are the things cannot be patented. Next thing, some patented invention. First one, that is we are aware of that. We may say that is a indelible link. So that the link mainly used by the largest democracy in the world. So whenever go for that is a National Physical Laboratory, New Delhi. So that is a licensee. Mysore Paints. Mysore Paints. Mysore is actually that company. Mysore Paints is the origin. He is a licensor for the particular ink. So that the indelible link. The indelible ink we are using whenever for that whenever some election purpose we are using such a ink. So that ink is being used for the election purpose for the last 40 years in India and abroad. So the origin is the Mysore Paints and Varnish Limited, Mysore. So that is the first one. The second one is we are actually we are knowing about that remote control power driller. So the remote control power driller is also one of the work for forming easier and comfortable and safer. These are some automatic electromechanical gadget, so which goes an attachment for the power drillers like that. So that is the second one. Third is a cloth clip. That cloth clip also the new thing. So that is a patented one.
Sir, sorry to interrupt. Sir, sorry to interrupt. Sometimes the meeting may end in under 1 or 2 minutes because it is only the limitation is only 50 minutes. So I have given another one link in the chat window. So if the meeting get disconnected, you can connect through the same meeting link. Yes.
So next thing is the idli maker. The idli maker earlier be used with cloth and other things. So after that they made it like that. That is a new invention. So that is also patented. So these are some of the patented inventions. So another important thing, life cycle of patent. So after the life cycle of patent, these are the life cycle. See, first we are filing a patent application along with the required documents. After that, the publication of the patent application. So the publication of the patent application. Before the publication of the patent application, some formal examination will be there. Once the formal examination is got over, then we go for the publication of the patent application. That idea will be that that cannot be what registered one. It can be automatically what patent idea will be vanished or like that. So within 12 months, we have to go for publication. That is a publication of application. So we have to go with the publication. So once we go with the publication, after publication, the validity is 48 months. So within 48 months, we go for the grant. So the grant, after all the examination is over, finally we end up with the granted of the patent. So these are the three important things: filing of the patent, publication of the patent, and granted of the patent. So these three important criteria, three important life cycle. So that is a thing. So, yeah. So what are the documents required for filing a patent application? First, Form 1 and 2. Form 1 and 2 is common for filing a patent. And if any drawing is needed, we make it as an annexer. So we can write some architectural diagram or flow diagram or like that. So that diagram is annexer 1. So after that we go, if any undertaking, if you want to make any undertaking, means that undertaking is not mandatory. If you want to undertake, we can go for the Form 3. And next, the declaration of the inventor is Form 5. And the document to claim the priority in the case of the conventional application, in the sense, we go for the another Form 9 like that. So finally, power of the authority like that. So in that cases, the patent specification has a two types: provisional specification and complete specification. So the provisional specifications mainly it comprises the description regarding the invention, only abstract it like that. That is a provisional specification. Next, the complete specification, it comprises the that is the second complete specification. It has the two important things: description and the claim. The description means what are the best mode in the detail and which the inventor considers for the practicing the invention like that. And along with that, some claim also we have to make it. So what are the claims? What are the novelty in what like that? So that we have to make it under the thing. So Form 1, Form 2, Form 9 is a very important for filing the patent and publishing the patent. So after that, we go for the Form 18 for examination. So these are the things. These are the documents required for patent application. So these are the patent process. So the first, we are having a pre-examination processing. So that will start with the we are classification of the determine the home for examination. So like that. So many processes are there. Just initial review will be there. Before filing, we are having the initial review. So after initial review is over, we go for the first action. The first action is allowed in the sense we go for sending the notice for allowance. Can you hear me?
It's audible, sir. It's audible.
Yeah. Yeah. So next important thing is semiconductor integrated circuit layout. Third important intellectual property is nothing but semiconductor integrated circuit IC layout. So all the motherboard or all the IC that all the circuit related integrated circuit related designs, all the designs belongs to the category of semiconductor IC layout design. So it belongs to the category of design. So that is all the semiconductor integrated circuit, a product having the transistor and other circuitry elements are designed to perform an electronic circuitry function. So all belongs to the category of semiconductor integrated circuit layout design. So it's act as per the act SICLDA, that is Semiconductor Integrated Circuit Layout Design Act 2000 deal with the layout design. All the layout design belongs to this category of IP. So this act provides the protection for a period of 10 years. So what are the criteria for registration of this such a semiconductor IC layout design? It should be original and it should be distinctive and it should be capable of distinguishing from any other layout design and it should not have been commercially exploited anywhere in the India or in a conventional country. So these are the criteria. So if it's so, okay, we will go for that semiconductor IC layout design. So these are some of the industrial design. So as per the industrial design, we are actually the design is some shape or some pattern or some arrangement of lines or some color combination which is ornamental in nature that is applied to any article like that. So here the design should be applied or applicable to any article by an industrial process. So it is registered for 10 years and it can extend by 5 years. So 10 plus 5, so 15 years. That is a fourth important IP, intellectual property. It's a design, any sort of design. So the design may be any shape or any pattern or any arrangement of lines or any color combination. So that belongs to the category of design. So what are the essentials of design in the sense that design should be eye-catching feature, or it should be new or original, it applicable to any article by an industrial process, or it should not be functional or useful, and it should not be artistic nature like painting or some sort of sculptures or etc. So these are the essential of a design. So here some of the here what are the industrial designs are there? Can you point out? Here, so totally 5 designs are there. In that 5 designs, some copyrights are there, some trademarks are there, some designs, some industrial designs are there. Can you point out what are the numbers? Which number belongs to industrial design? Number 1, that is some art painting work. Number 2 is some sort of thing, some sort of what a statue or something. Number 3 is that iPad designer like that. Number 4, number 4 is nothing but some logo, the McDonald's logo like that. Number 5, the 5 is the some Coca-Cola. So here, can you point out which one is the industrial design? Which number or which one belongs to industrial design? Anyone? Are you all there? So we may say 3 and 5. 3 is the logo that it's Apple, iPad Apple. So that is a 3 and 5 is the industrial design. Number 1 is a painting. So number 1 is a Mona Lisa. That is an artistic work. That is a painting. So it covered under the copyright. And the 4 is a branding logo. So the branding logo is a McDonald's. The branding logo is protected under the trademark. So these are the things. So these are the things. So this is for your understanding purpose. So next, another important thing, geographical indication. That is another fifth industrial property is the geographical indication. So geographical indication, GI is primarily an agriculture, or it's a natural or a manufactured product, some sort of, that is a handicraft or some industrial goods, origin is in a definite geographical territory. So we may say that is a silk. So silk is a common, but the silk, Mysore silk or Kanjipuram silk, like that. So the before the silk is a product. So silk is a one cloth or is a product. It's a manufactured product. That manufactured product with some originating country, originating area, that is originating geographical territory. So silk, here we are making a Mysore silk or we are Kanjipuram silk, like that. So like that here Rajasthani Katputis, Naga Mitta, Darjeeling tea, like that. So these are the things, these are the belongs to the geographical indication. So that geographical indication is nothing but specifically such a name conveys an assurance of a quality and distinctiveness which is essentially attributable to the fact of its origin in that different geographical locality. We may say Darjeeling tea, like that, that's the thing. Some example is what Kanjipuram tea curry, what we may say Agra beta, like that. We may say some what Kolga chappal, like that. So these are the belongs to the geographical indication. So that's another important thing. So what are the essential? What are the essential of geographical indication? It's a primarily an agriculture natural product. The product is considered to be a manufactured in some territory, some area. It convey an assurance of the quality and as well as promote the economic prosperity of the producers. So next, the validation of that such a GI is the 10 years. So it can be renewed from the time to time for the period of 10 years also. So that is essential of the geographical indication. The next important thing is the plant variety. So that is also one important thing. Under the plant varieties, the plant variety is the India's production of the plant varieties and Farmers Right Act. Based on that, they are producing such a sort of such production is a unique aspect of Indian IP regime, which recognizes the farmer as a cultivator or conserver or breeder, like that. So with the help of the plant variety, so that is also under the IPR. So this plant variety provide for the establishment of an effective system for production of the plant variety. That's the right of the farmer. So some plant breeders or encourage the development of the new varieties of the plant for that. The Act was enacted to meet the obligation under the article of I think 27 of the TRIPS Act. They have made it this plant variety act. So the plant variety may be some sort of pearl millet, some rice, or some types of green gram, some types of wheat, some types of cotton, like that. So these are the things under the plant variety. This is also one industrial property. So next important thing, some sort of genetic resources as well as the traditional knowledge. So that genetic resources, that is also genetic resources also can be a this also one form of IP. Example of the genetic resources, we may say the material of the plant, some animal or some microbial origin, such as some medicinal plant, agriculture crops or animal breed. That is make it as a genetic resources. And the traditional knowledge is nothing but knowledge or skills or some sort of practices. So that type of things we are under the traditional knowledge. So genetic resources and traditional knowledge, that is also under the category, under the Act of Biological Diversity Act 2002. It was enacted for the preservation of the biological diversity in India and provide a mechanism for equitable sharing of the benefits arising out of the use of the traditional biological resources and the knowledge. So from Ayurvedic, all the Ayurvedic product can be under the category of genetic resources and the traditional knowledge, like that. So traditional knowledge digital library. So we may get it from that Minister of Ayush. So all the traditional knowledge information are available in that ministry. are used. So it encourages the modern research based on the traditional knowledge, as well as it access given to the several international patent offices, so that it maintains the ancient knowledge and traditionally past verbal knowledge, that is knowledge about the medicinal plant like that. So the translations available in 5 international languages, that is English, Japanese, French, Spanish, and German. So they are translating from Tamil into English, Japanese, French, Spanish, and German like that. So even sometimes we may say yoga, Unani Siddha, so that type of thing also under the category of the traditional knowledge as well as the some genetic resource like that. So another important intellectual property is the trade secret. So the trade secret is nothing but is any secret which is extremely vital for any company's growth or crucial for its survival or any sort of business entrepreneur, some sort of companies, they ensure that they effectively protect their business process and the technical know-how and confidential information from their rivals and some competitors are like that. So that is a trade secret. So that trade secret also we make it under the some secret or we make it confidential in terms of that trade secret IP. So that is another very, very important thing. So all the Indian industry or Indian company or some sort of consumer, they are protecting their idea in terms of trade with the help of the trade secret. So the trade secret can be protected for an unlimited period of time. That's a very important thing. So India, like many other countries, such as UK, Singapore, Malaysia, New Zealand, Australia, etc., has a common law approach to trade secret. So that is an important thing. So the trade secret, they must not be known or really accessible by people who usually deal with such kind of information. Second, it must have commercial value as a secret. Next, the important thing is lawful owner. It must take a reasonable effort to maintain its secrecy. So this is a trade secret. So what are the IP offices in India? The IP offices in India, Delhi, the patent office in Kolkata, Delhi, Chennai, Mumbai, and design wing is the Kolkata, trademark registry is the Mumbai, Delhi, Kolkata, Chennai, Ahmedabad, GI registry is in Chennai only, and copyright office in head office in Delhi only. So all the thing, actually, so far we have seen so many IPR, intellectual property rights, and different types. So you may get it from ipindia.nic.in. You may check what are the things, how we are making it all the way. So that is a check the status of your file application and what about commercial, how to make the commercial them and how to undertake the further research like that. So everything you can make it, you can search it from ipindia.nic.in. How can you contribute? How can you contribute to IP intellectual property? So the first thing is innovative. So be innovative, and don't buy the fake things and think outside the box in order next to produce the original work. So the original work can be go for that IP, that is intellectual property. So this is the thing innovation, that think outside the box and produce the original work like that. So these are some of the useful links. CIPM website, DAP website. So startup in the action plan. So some of the WIPO. Another important thing, WIPO, WIPO is nothing but that World Industrial Property Organization. As per that, every country having their own IP office. As per that, here WIPO is a worldwide that industrial property office. So we suppose we go for filing or publishing or patent in the international listing, we go with the WIPO.int like that. So this is at the outset, it is obvious that the management of IP and IPR, it is a, we may say it's a multi-dimensional task and calls for many different actions and strategies which need to be aligned with the national laws and international practices as well as the international practices. It is no longer driven purely by a national perspective. So IP and its associated rights are seriously influenced by the market needs, the market response, as well as the cost involved in translating IP into commercial venture, and so on. So in other words, we may say trade and commerce. Trade and commerce, the considerations are important in the management of IP. the trading as well as the commercial commerce, trade and commerce. These two keywords is very important in the IPR. Trade and commerce considerations are the important in the management of IPR. So thanking you. Any questions?
Yeah, so those who have queries, you can type in the chat window. I will just consolidate and you will be telling to the resource person. Second thing is the feedback link will be shared in your chat window. So those who want to fill the feedback link, you can fill that link also. Those who have any doubts, please feel free to type in the chat window. Yes, any queries from your side? So those who don't have queries, you please fill up the feedback form so that we can send you the certificates in another 1 or 2 days. Kindly fill up the feedback form. Anyone having queries, you can type in the chat window. Yes, 1 minute. I'll just check with the.
Okay, Manoj.
Sir, I would like to thank Dr. Balakrishnan for spending his valuable time with us. And we have received a number of information related to the intellectual property rights. And in case of any such queries, feel free to chat and use that WhatsApp group. If you don't have any other thing, you can ask in the WhatsApp group. The WhatsApp group will be active for 1 or 2 days until the certificate will be generated. So until that, you can ask the queries in that too. So thank you so much, sir, on behalf of CSB's department and on behalf of all the participants here, sir.
Yeah.
It was a wonderful session. So participants, 1 minute. I'll just check the link. I'll just check the link 1 minute. Yes. So I think now you can do that. I think now you can do you can submit. Now you can submit the. Yes. Now you can submit. I think the restrictions will be removed. So now you can submit. The same feedback form is also